Well, from conservation easement to tax regulations, federal and state laws frequently intersect with agriculture and rural landowners. Today, we're going to look at some of the latest developments and what they could mean for your operation. Our good friend, Roger McEowen with the Washburn School of Law joins us now for a breakdown. Roger, as always, a pleasure. The first case that we're going to look at, this involves donated conservation easement tax fraud. So talk about the highlights with this one.
Yeah, Suzanne, good to be with you. This one involved the valuation of a donated easement. It's the latest in the line of a number of conservation easement cases, and IRS has guidelines, but it basically comes down on the valuation issue to the value of your property before the easement is donated to the land trust or the qualified charity, that is, and after the donation. And the difference is the value of the easement that you get a tax deduction for. And here the parties involved schemed to inflate the value of the easement. They told the appraisers in advance what value they wanted, and you can't do it that way. IRS blew the whole thing up. They said there's no donative intent, there was no qualified appraiser, on and on it went. And they lost. What they were trying to get was about a $21 million deduction. It turned out to be about $5 million.
Oh my gosh, what a big difference, right? So producers, what do they need to know when we're talking about the rules then for donated conservation easements?
Well, don't scheme, and if you see the terminology syndicated conservation easement, run as fast and as far away from that as you can. There were criminal penalties in this case. Last year was the criminal phase of this, and this was the tax court phase of this case. So it's an absolute mess. The rules are technical in nature, but if you do it right, a qualified farmer or rancher can get a 100% tax deduction, that 100% of their contribution base, that is. And it can provide some nice tax benefits to farmers and ranchers. But of course, you're losing up control over that part of your property. So you have a lot of things to consider before you get into this.
Well, the next case, Roger, that you're going to look at for us involves an intentionally defective grantor trust, which is a tool used in estate planning. So tell us the background on this case.
Yeah, an IDGT, which is the acronym for this, is an estate planning device for relatively wealthier people. And that's going to get redefined if Congress does nothing. Starting in 2026, we're going to find out that more people are suddenly wealthy that they didn't think. But this is a way to keep the property out of your estate at death for estate tax purposes and enhance the appreciation, the value of the appreciated wealth that's in that trust in the hands of the next generation. So if you're doing a succession plan for your farm and you're up above the threshold for federal estate taxability, this would be a technique that you want to consider. Now, the grantor still has to pay any income tax on income generated by the assets in the trust even though those assets have been transferred away from you. That's why it's called an intentionally defective trust. But that allows that property to build up in the heir's hands tax-free. Well, IRS has said if you have cash flow problems and you don't have enough income to pay the tax, then the trustee of the trust can reimburse you. Now IRS has changed their position on that and said, well, you can do that, but it creates a gift tax. So we're going to have to work our way through the clauses that we put in trust to perhaps get around what IRS is saying here, if there's a way. This is brand new, so we're still trying to work out the mechanics of how we are going to deal with this.
And that's the confusion I find when the IRS goes ahead and changes these new rules and how that works. You really have to be well versed in that or know someone like yourself that does. Hey, Roger, before I let you go, I know we're talking about some cases currently pending before SCOTUS. What are you expecting as we move forward?
Oh, we've got two huge cases at the Supreme Court right now that are going to bear on farmers and ranchers. One is whether the Congress can set up a tax without a taxable event. And that's a very important case, because if they say that the tax code can tax you on something that you haven't had a tax realization event, that has implications for stepped-up basis at death. And that gets us back to what Senator Elizabeth Warren has been wanting for some time, and that's a wealth tax. That would be devastating to agriculture, as well as other small businesses. Another case that's out there that's pending, and they will decide this in the next month or by the end of June, has to do with buy-sell agreements. And if you have a buy-sell agreement, which we suggest in many transition plans for farmers and ranchers that they have this very important aspect, that if the insurance is paid to your entity, to your corporation, for example, does that when you have a shareholder that dies, does that increase the value of the stock base, which then enhances the deceased shareholder's estate for estate tax purposes? The lower court said yes. We'll see what the Supreme Court says on that. That one will have big implications for transition planning for farmers and ranchers.
Absolutely. So interesting. Thank you for following these cases. I appreciate all the information as always. We love having you here. Roger McEowen with the Washburn School of Law.